Good afternoon, everyone, and welcome. My name is Marianne Monteleone, Director of Education for LIBOR, and welcome to LIBOR's Wednesday webinar. We're happy that you could join us today, and this Wednesday concludes our dedication to every Wednesday throughout the month of April, dedicated to diversity, equity, and inclusion, since it is National Fair Housing Month. We have two very special guests here with us today, one who is no stranger to LIBOR, who always responds when we reach out to her, who is Dawn Lott. So let me give you a brief introduction of Dawn, and we're happy to have Lorena Gonzalez, a principal investigator with Suffolk County, here with us today as well. So Dawn Lott is the Executive Director of Suffolk County Human Rights Commission. Originally created in 1963 to work to the elimination of bias and discrimination, in January 2015, the mission of the Human Rights Commission was expanded to include domestic violence, veteran, and military status issues. Ms. Lott is an attorney who resides in the town of Smithtown, and in her position, Dawn works with 15 commission members establishing policy for Suffolk County with a focus on education and complaint investigation. So I turn it over to both of you, and I thank you both, Dawn and Lorena, for being here with us today.
Well, good morning, everyone, and good morning, Marianne, for inviting us back. Once again, I am no stranger. So today we're going to be discussing Suffolk County fair housing laws and what you should know. And I believe that there's going to be an opportunity for you to ask questions. There's a Q&A portion of this. So with no further delay, we will get started. So what is the Human Rights Commission? The Human Rights Commission, we are a government agency and we provide services to the residents of Suffolk County at no cost. As Marianne had indicated, we were established in the 1960s, and we realized that complete elimination of bias and discrimination may be impossible, but having agencies like ours, which enforces laws prohibiting discrimination and which provide public education, help to address this problem. We also we have a work share agreement or an MOU with the New York State Division of Human Rights, and we also work with the EEOC and HUD to avoid duplication of services. So if you file a complaint with the commission, it can be filed simultaneously with the state and federal agencies, and there is no need to go to the three offices. We are governed by 15 commissioners, and these are commissioners who I report to, and they are volunteers and they meet monthly, and their purpose is really to promulgate rules and policies to ensure that the mission of the Human Rights Commission goes forward. In addition to that, we do have staff members. Again, I am the executive director, and we have investigators who are tasked with the responsibility of conducting the investigations that come to our office. As I indicated, our goal really is to ensure that all individuals are treated with dignity and respect, and that all the residents of Suffolk County are afforded an equal and fair opportunity to enjoy a full and a productive life. Now, what does the commission do? Well, as I indicated, we investigate. So we investigate and we enforce both federal, state, and county human rights laws, anti-discrimination, fair housing, and equal employment laws. In addition, we conduct informational sessions such as the one we have here and trainings throughout Suffolk County. And as I indicated, we work toward the elimination of bias and discrimination. It's important to understand what our jurisdiction is. And so when we say jurisdiction, this allows us the opportunity to investigate. So we can't investigate anything and everything, but what is jurisdiction for us? Well, the allegation or the incident has to have occurred within Suffolk County. We are fortunate that we do have a Nassau County Human Rights Commission, but for our purposes, the incident has to have occurred within Suffolk County. In addition, there's a one-year statute of limitations. And basically what that means is that the incident, the alleged discriminatory act, has to have occurred within 365 days. And then there are a variety of areas that we cover. So they include employment, housing, which we'll definitely get more into throughout the presentation. When we talk about employment, we're talking about any employer who has one or more employees, and that was as of January of 2020. And on a federal level, it's 15 or more employees. Housing, as I indicated, public accommodation, and public accommodation refers to places open to the public, such as stores, restaurants, movie theaters, libraries. In addition, there's credit. We also have volunteer fire departments, labor unions, education, and just recently we were tasked with the responsibility of reviewing all police misconduct cases that have been filed against the Suffolk County Police Department. In addition to establishing the areas that I just articulated, we also, in order for us to obtain jurisdiction, there has to be an unlawful practice. And basically what that means is that there has to be an allegation that there has been some act which was based upon someone's membership into a protected category or the perception that someone belongs to a protected category. And we're going to get more into what we mean by a protected category in a few moments. But at this point, I'll turn it over to Lorena.
Thank you, Dawn. So yes, before we talk about protected categories, I'd like to talk a little bit more about my next screen, which is bias and implicit bias. So what is implicit bias, right? What is it? What is it exactly? If you go to the next slide, you'll see a whole bunch of phrases. You'll see old, tall, weak, short, gay, female. These are all things that it says what we don't think we think, right? So implicit bias is not something that we're automatically aware of, right? And the definition of the implicit bias: the attitudes or stereotypes that affect our understanding, actions, and decisions in an unconscious manner, activated involuntarily, without awareness or intentional control. We cannot control these attitudes or stereotypes, and that's where implicit bias comes in. So some examples of implicit bias: we have ableism. If you look at the picture, you'll see what you kind of get an idea that it has to do with ability-based bias, right? Ability-based bias, or ableism, is a set of beliefs or practices that devalue or discriminate against people with disabilities. So that is what ableism is. Our next example is sex-based bias. It's pretty obvious, right? So a definition: sex-based bias is behavior that shows favoritism toward one sex over another. Most often, its sex bias is the act of favoring men and or boys over women and or girls, or it could be vice versa also. The next example is LGBTQ bias. What is LGBTQ bias? LGBTQ bias is a personal and unreasoned judgment or fear made solely on an individual's sexual orientation or gender identity. Another example is creed. If you see all the signs here, these are all what we have: religious signs, right? So what is creed-based bias? Creed or religious bias is when you treat a person or group differently because of the particular beliefs which they hold about a religion. The next slide, we have age. So we have age-based bias. What is age-based bias? Age-based bias is, or ageism, they call it also, is when someone treats you unfairly because of your age, whether it's because either they feel you're too young or you're too old. Another bias is race. And as you see all the pictures of all the different races. And what is race-based bias? And what is race? First of all, the definition. Definition of race we have is usually associated with biology and linked with physical characteristics such as skin color or hair texture. And race-based bias is a personal and sometimes unreasoned judgment made solely on an individual's race. So these are all examples of different, there's probably many other kinds of biases, but what do we have? Do we all have biases? Yes, we all have these. We all have to recognize that we have these biases. And why do we need to do that? So we don't act upon them. So that's where the question is, right? What is the question? The question is, what is with regards to the next, when do biases become unlawful, right? When is it unlawful? A bias is unlawful, they aren't in and of themselves, right? But when they lead to discrimination. So when we do act upon these biases, that is when they become unlawful. When conduct is based upon one's membership, perceived membership in a protected category. And that's where the protected categories are going to come in. The protected, so there are, what is a protected category, first of all, right? So not all discrimination is illegal, right? There are certain categories listed within the human rights law that are specifically protected from discrimination, right? So not all discrimination, you may have a personality conflict with a particular candidate, you may have an issue with somebody that's personal, and it may not be necessarily discriminatory. But discrimination is, and again, we're going to talk about the protected categories, which have a lot to do with some of the categories that I mentioned in the biases, right? So the first one we're going to talk about is race. So we talked about racial bias, also visible traits. So that is a protected category. Also color. So race and color, they sometimes go together, sometimes they don't. National origin. National origin, birthplace, culture, linguistic characteristics of a particular group is included in national origin. Also, the Suffolk County law, our local law, includes alienage and citizenship status. So that would be the citizenship of any individual, the immigration status of any individual legally eligible to be employed in the United States that is not a citizen. Sex and gender identity, right? We talked about some sexual biases, right? So sex and gender are a little bit different, right? Sex includes physical attributes assigned at birth, male, female, intersex, and also includes the physiological characteristics such as reproductive organs. Gender identity, on the other hand, is more related to an individual's self-image or gender identity, appearance, behavior, or expression, whether or not it is different from that traditionally associated with the legal sex assigned at birth. Right? So there's a broad spectrum of gender identity. We have sexual orientation, right? So sexual orientation is being heterosexual, homosexual, or bisexual. And that's where sexual orientation. And we have creed, which we talked about, religion, religious discrimination, also visible traits, garments of religious nature. And there's also not having any religion or being an atheist. That's also protected under the human rights law. We have disability. Disability is a very broad category. It's covered in all areas of discrimination, including housing. And, we'll talk about later about housing and disability and accommodations for disabled individuals. We have age. Age is a covered category in all categories except public accommodations. So it's for anybody that's 18 or over in housing. We also have marital status. Marital status protects people from being discriminated because they're not married, or because they are divorced, or because they are single. The next category would be familial status. So definition, familial status, any person who is pregnant or has a child or is in the process of securing legal custody of any individual who has not attained the age of 18 years. It could be one or more individuals who have not yet are 18 years old. And it could be a parent or another person having legal custody of such individual. So that's where familial status comes in. Veteran status is a protection that is covered under the housing section of our law, and it's past participation in the military, and the discharge status other than dishonorable. We also have military status protected under all areas, covers persons participating in the military service of the United States or the military service of the state. Its current participation, active participation, or also if you're in the reserves. Conviction record is a covered category for employment only, conviction and arrest record. And Dawn is going to talk a little bit more about the housing situation with that. And status as a victim of domestic violence. So if you're a victim of domestic violence, you are protected under the human rights law in housing and in employment. And we also have lawful source of income. I'm going to delve a little bit more into that when we talk about the housing section of the law. And last but not least, unlawful salary inquiry That's in employment. It's an employment, it's protected category in employment. And now, last but not least, is retaliation. So retaliation is, it would be unlawful to retaliate against an individual for filing a charge of discrimination, participating in an investigation, or opposing discriminatory practices, even if the complaint gets dismissed. And association is something that we added in here because all these categories are covered under the human rights law, and also association to anybody that belongs to this category. For instance, in a housing situation, if you have guests coming over and visiting and they're from a particular protected category, they're also protected under the human rights law. Does anybody have any questions, Marianne, on any of these?
Okay, so we'll continue. So we're really here today to really talk about fair housing laws. And it is important to note that fair housing laws are not the same as landlord-tenant laws. Fair housing laws was predicated upon the principle that access to housing is a civil right. Equal access and opportunities for housing should be afforded to all, regardless of their membership in a protected category. And protected classes are those, or categories are those historically discriminated against by either being denied housing or being denied access. Landlord-tenant laws apply to all rentals, and they explain expectations and procedures for both the tenant and the landlord. However, fair housing laws only apply in situations where a protected category is involved. For example, the state's Landlord-Tenant Act says that a housing provider must make necessary repairs to appliances, plumbing, electrical systems. If the landlord doesn't make repairs for tenants, that is a landlord-tenant issue. However, it can become a fair housing issue too if there is different treatment based upon a protected class, like when a landlord prepares or makes repairs for all tenants, except perhaps those who are the recipients of a Section 8 voucher. Next, we're just going to, I'll tell you that the laws that we're going to be talking about in part of our presentation today are the Civil Rights Act of 1866, which was the first federal law prohibiting racial discrimination in housing. I hope you all are familiar with the Fair Housing Act, also known as Title VIII of the Civil Rights Act of 1968. And along with that came amendments in 1988. And then we have the New York State Human Rights Law, also known as Executive Law Article 15, as well as our Suffolk County Human Rights Law, Chapter 528. So in terms of the Fair Housing Act, the Fair Housing Act made it unlawful to discriminate based upon race, color, national origin, religion, handicap or disability, and sex. And so when we talk about disability, again, that was an amendment in 1988, disability is defined as an individual with a physical or mental impairment that substantially limits one or more major life activities, which is defined as walking, sleeping, things that we sometimes take for granted. Disability is also considered having a record of such an impairment or being regarded as having such an impairment. Disability discrimination can mean treating one differently because they have a disability, or it can mean a refusal to provide a reasonable accommodation or refusal to provide a reasonable modification. And we'll talk a little bit more about the requirement to provide a reasonable accommodation or modification. When we talk about familial status, which was another amendment that was added also in 1988. Familial status, as Lorena indicated, it's families with children under the age of 18 or pregnant women. So it protects pregnant women, people adopting children. So you can't refuse to sell or rent a home to a family because they have children. Also, you can't require additional security deposits or charge for families with children that is not required of other residents. You cannot segregate families with children to certain areas of a housing complex, nor can you limit the use of a housing complex, pools, elevators, and other services to adults, except if we're talking about for safety reasons. What's also prohibited is discriminatory advertisement as it relates to someone's family status. So saying no signs or couples only or single person or also would run afoul of the Fair Housing Act. The exemption would be, however, a housing that's provided for persons 62 or older. New York State also has protected classes, and what you'll note, I'll list them. Oh, sorry, there we go. So we have race, we have creed, we have color, national origin, sex, age, and that's over age 18, disability, marital status, military status, family status, sexual orientation, gender identity, lawful source of income, and arrest and sealed conviction record. And so we will talk more about the lawful source of income when we get into that portion of our presentation. We can talk more about that. But in addition, right, so those are all the categories, and retaliation is also one of the categories as well. When we talk about the Suffolk County protected categories, and I think, Lorena, you'll pick up from this slide where we walked through federal protected categories. We walked through New York State, their protected categories, and now we'll go over Suffolk County. And what you'll start to see is that the federal protected categories are not as broad as state. So state covers all the federal protected categories, and our local laws covers all of the state, with the exception when we talk about housing, with the exception of arrest records or sealed records. And there are other few distinctions here. So also when we talk about victims of domestic violence, is not also covered in New York. But in any event, I'll turn it over to you, Lorena. Oh, no, I'm not turning it over to you. 1 second, I'm sorry. 1 second, I'm not turning it over to you. We're going to stick for a minute with the Fair Housing Act, and we'll talk about what are some of the housing, what type of housing is covered under the Fair Housing Act. So it would be single family homes owned by private persons when a real estate broker and/or discriminatory advertising is used to sell or rent a home. Also, single family homes that are not owned by private persons, even if the broker is not used to sell or rent a home. Then it would include multifamily dwellings with 5 or more units, including rooming houses, as well as multifamily dwellings with 4 or less units if the owner does not live in one of the units. So we talked about this law. We've talked about New York State. We've talked about Suffolk County human rights law. Who must comply with these laws? Well, it would be the owners of the property. It would be property managers, property maintenance staff, tenants, subtenants, managing agents, real estate brokers or agents, mortgage lenders and financial institutions, advertising media, agents and employees of any of those persons listed above. What types of conduct is prohibited? And this would be conduct, again, which is based upon a protected category. So it is unlawful to refuse to sell, rent, or lease a housing accommodation because someone is a member of a protected category. The refusal to negotiate for the sale or rental or lease. To discriminate in terms, conditions, or privileges of the sale, rental, or lease of a housing accommodation, as well as to misrepresent the availability of the housing accommodation or the terms and conditions of the transaction. In addition, it's unlawful to refuse to permit reasonable modifications of the premises to individuals with a disability if necessary to afford full enjoyment of the premises. And so when we talk about reasonable modifications, oftentimes what you should know is that the reasonable modifications are made at the expense of the person with a disability, except in New York State where we're talking about public or common use areas. And the reasonable accommodation must be reasonable. So a landlord can request a renter to restore the interior or the original condition when vacating the premises. The refusal to make reasonable accommodations, to refuse to make reasonable accommodations and rules, practices, or services to afford someone or an individual with a disability the equal use and joy of their housing accommodation would be a violation. When we talk about reasonable modifications, we usually see it in the context of or accommodations, we usually see it in the context of a no pet policy. No pet policies are permitted. However, there has to be exceptions, and those exceptions would be for someone who has an emotional support animal. In addition to when we talk about reasonable accommodation, the accommodation really does have to be reasonable. So it cannot impose a financial or an administrative hardship on the housing provider. I mentioned a while ago, we talked about emotional support animals, and I know you all are familiar with service animals as well. And we know that service animals are defined as working animals and not pets. And this is different. The Americans with Disability Act defines service animals as any dog that is individually trained to do work or perform tasks for the benefit of an individual who has a disability, including a physical or intellectual or mental disability. So there is no requirement that the animal be licensed or certified by any entity. The task performed must be related to the person's disability, and the task may include seizure assistance, pulling a wheelchair, alerting to sounds or allergens. Miniature horses are used as service animals. To determine if a dog is a service animal, you can ask, is a service animal required because of a disability, or what work or task has the dog been trained to perform? Service animals in public, they must be permitted in all areas where public is allowed, for example, a hospital patient room, but not an operating room where there's a sterile, sterile environment. When we talk about emotional support animal, this is the protection specifically found under the Fair Housing Act. It's a broader definition in that the animal provider provides comfort and support. Whether the request for documentation, you have to make sure that the request for documentation, that there's a correlation between the disability and the requested change. If the disability is not clear, you may request the person to verify the disability or the disability related need for the accommodation or modification. It can come from a healthcare provider, qualified third party. You don't want to ask about disability or medical records, however. And again, the reasonable accommodation or modification, it's reasonable if it is related to the person's disability needs. And again, it is not an undue or an administrative financial burden. And it does not fundamentally alter the nature of the provider's operations. In addition to what else is prohibited, the refusal, again, to make reasonable accommodations, as I just went over. In addition, in New York, as I indicated, when we talk about seeing impairment, individuals seeing impairment, so the use of a guide dog, or a person with a hearing impairment, the use of a hearing dog. And again, it's discriminatory to not allow for the use of a service dog or an emotional support animal. But what else is discriminatory? What else is prohibited conduct? Discriminatory advertising. It's unlawful to discriminate to print, to publish any statement or advertisement or publication, or to use any application which expressly limits someone and identifies their group identity or their lawful source of income. In addition, additional unlawful practices include staring, and we know that staring is the attempt to direct racial or ethnic classes to specific areas in an effort to maintain segregated living patterns. Then we have retaliation. So retaliation is when there is someone who is opposing, say, housing discrimination, and they suffer a negative consequence. And that can be, for example, a real estate agency fires an employee for reporting that a landlord refused to rent to her, say, her African-American client, for instance. Also unlawful is blockbusting or panic peddling, which is what is also known, where a real estate agent frightens people to move out of one neighborhood because of a fear of a rapid influx in minority individuals. So white owners may feel compelled to leave the neighborhood and are induced to sell at a reduced or below the fair market value, and these units are then resold to other minority groups at a higher amount, thereby, having a higher profit. And then we also have redlining, which is the illegal practice of denying products or services in an area due to its racial or its ethnic demographics. And so now I will turn it over to Lorena, and she's going to talk about specifically Suffolk County human rights law as it pertains to housing.
Thank you, Dawn. Okay, so again, we have at the Suffolk County, the law, Chapter 528, it includes all the categories that the federal law includes, and it includes all the categories that the state law includes. We call those protected categories group identities, as I mentioned before. It is pretty much the same thing. The protected categories are under the Suffolk County law are called group identity. We also add veteran status as a protection under the housing law, and we mentioned what veteran status was, lawful source of income, and we're going to talk a little bit more about that. And we also mentioned the definition of alienage and citizenship status. It's something that is included in our Chapter 528 that may not be included in the other laws. So let's go into a little bit more about what lawful source of income is. So lawful source of income includes, but it's not limited to, income derived from Social Security or any form of federal, state, or local public assistance or housing assistance, including the Housing Choice Voucher Program. So including anybody that's on Social Security, disability, Section 8, or any other lawful source of income. Now, who does it apply to? Okay, so this law applies to housing accommodations with 3 or more units, and also to housing accommodations offered for sale, rental, or lease by any person with the right to sell, rent, or lease 3 or more housing accommodations within Suffolk County. So first of all, I want to just kind of define what a housing accommodation is. What is a housing accommodation? Any building, structure, or portion thereof which is used or occupied or is intended or designed to be used or occupied as the home, residence, or sleeping place of one or more human beings, and any vacant land offered for sale or lease for the construction or location thereon of any such building or structure. So that is pretty much a definition of what a housing accommodation is, very broad. And again, I'll give you a couple of scenarios, examples of who is subjected to this law. The first scenario is going to be a landlord owns an apartment building in Suffolk County, which contains 3 or more rental units and is offering 1 or more for rent. So it could be an apartment complex, it could be in a building, as long as the landlord owns 3 or more rental units in that particular area. And it could be, like I said, a big apartment complex or anything that's 3 or more in there. The next scenario is if the landlord plans to rent an entire single family home to one family. So he owns that home, he plans to rent it to one family, and the landlord owns at least 2 other housing accommodations within Suffolk County. So in both these scenarios, this landlord would be subjected to the lawful source of income portion of the law. So with regards to the next slide, we're going to talk a little bit about the exemption. There is an exemption to our Suffolk County human rights housing law. And that exemption is, it's also called it's owner-occupied exemption, but it's also called Mrs. Murphy's exemption, right? So the exemption under Suffolk County human rights law applies to the rental of housing accommodations in a building with no more than 2 housing accommodations if the owner or a member of his or her family resides in one of the housing accommodations. So if the owner occupies, for instance, he owns a 2-family home, that's his only home, that's his home, and he's trying to rent out either the first floor or the second floor of his home, and he lives in there, he is not subjected to the housing portion of the law. There is one recent development, though, in the state of New York. It's New York state law, that there's no longer an exemption from this prohibitions against discriminatory advertising. That means if the landlord engages in discriminatory advertising or inquiries, it will cause the owner of the property to lose this exemption. Even though it's owner occupied, he's going to lose this exemption if he engages in discriminatory advertising. And he will no longer be exempt from any portion of the protections under the human rights law. So that is an exemption. It's under the state law, and it's an amendment, a recent amendment to the state law. Also, the law does not apply to rentals in rooming houses occupied by the owner or a member of the owner's family. So that's also an exemption to the housing protection of the law, the housing portion of the law. So is that my?
That's okay. I'll pick it up from here.
Oh, okay, no problem.
So next, we'll just briefly go over what, how does the commission, how do we go about investigating complaints? So one of the things is that we conduct extensive intake with the complainants, and it's important to note that when a complainant comes to us, they are allegations, and so we listen very intently to what it is that their allegations, and we take down the intake, and we make sure that we have all of the details that they provide. Once we have that information, then we contact the respondent, and we can either contact the respondent by letter or by phone call, usually by letter, to get their side of the story, because it is important to hear their side of the story. And then if there are any witnesses that have been identified by either party, we endeavor to interview those individuals. If the case warrants, we will do on-site visitations to determine whether or not the information or the evidence that either party is providing us, if it comports with what they're saying, and whether or not if it's something that is it involves the site visit, then we will go out and we will do a site visit. In addition to gathering that additional information, we do ask for documents. So it's a reduction of documents. And again, this is from both parties. At times, we have conducted a 2-party fact-finding conference, and basically that's an opportunity for both parties to share what information, what evidence they feel is relevant to their claims and or their defenses, and we will give them an opportunity to provide us with that information. We do engage in settlement discussions. There are cases that are ripe for settlement, and so we try to identify those cases early on, because we do know that when someone is talking about filing a complaint, and with someone that has the responsibility of defending, that it can take its toll. So we try to resolve matters expeditiously as possible, but it doesn't always happen. In the event that we find that discrimination has occurred, there are remedies under the law that a victim of discrimination is entitled to recover, and they can include a cease and desist order. It can include reinstatement and hire and promotion if we're talking about particularly in an employment context. The damages that they would be entitled to recover is back pay, possibly front pay. We talked early on about making housing accommodations. That would be something that, again, we would try to negotiate, or if there's a final determination of discrimination, that may be a remedy that we would issue. In addition to that, we could request if there was an eviction proceeding that had been commenced, that the eviction proceeding be stopped or held in abeyance until we may be able to resolve the matter. There are other monetary losses that the complainant may be entitled to. There is payment for mental anguish. There's also changes in the employer or the housing provider's policies, which we, if that were part of our remedy, this would all be documented, and would be either in a settlement agreement, or it would be in the final decision order that is issued by our office. There are also opportunities for a complainant to recover attorney's fees. Let me just go back in terms of remedies. So the civil penalties can be hefty. So up to $50,000, up to $100,000 if it is deemed that the conduct was willful, wanton, or malicious. And with housing discrimination only, there is an additional punitive damages up to $10,000. Excuse me, $10,000. In addition, what else does the commission do? Well, we take, as I alluded to earlier, we take complaints of police misconduct against the Suffolk County Police. We also are involved in community disputes, and we try to mediate racial tensions. And this really comes with the assistance of our Suffolk County Anti-Bias Task Force, which is a sub-division of the Human Rights Commission. We also do educational presentations, and we hold public hearings and educational conferences. And that is it in terms of what it is that we do. But what is it that you can do to prevent illegal discrimination? Well, one, I think the first thing to do is to recognize your biases. As Lorena indicated, we all have them, and to recognize them, I think, is the first step. The other thing is what you're doing here today, which is becoming familiar with the laws, specifically today in terms of fair housing laws. Then you also make appropriate referrals to the Human Rights Commission when warranted. And as we indicated before, we work with the New York State Division of Human Rights, EEOC, and HUD. And when you hear it, you don't participate in racial, sexual, or religious jokes or harassment. So you don't want to be a part of the problem. And I know this was a lot of information that we provided to you. We don't expect people to be experts, but if you do witness something that you think is discriminatory or that runs afoul of the laws that you have just heard or that you learned about it, we ask you to report it. Report it to us or report it to any other law enforcement agency. And that really concludes our presentation for today. We indicated that we would be open to answering any questions. So I'm not sure in the Q&A if questions have been presented, but we'll take them at this time.
Okay, Dawn, yes, we do have a few. Thank you. A lot of information. So we have a question. Does the Mrs. Murphy exemption that Lorena talked about apply to real estate brokers if the owner lists the rental with the use of a broker?
Yes, Lorena, you want to take that?
Yes, it does apply to real estate brokers. Real estate brokers are also subjected to the law. If that should happen, then the real estate broker should not participate in that line of advertisement. And also, they should report it to the Human Rights Commission.
Okay, hopefully, if that didn't answer the question, please put another comment in the Q&A, and Dawn or Lorena will be sure to answer. Another one is, and I've heard this before, can a landlord require a credit check for an applicant with a housing voucher?
So I think we've heard this one before too, in terms of credit checks. So one of the first things I would like, I just go back to stating is that what is the purpose of the fair housing laws, right? And the fair housing laws is to give everybody a fair and equal opportunity, and to make sure that any policies and procedures that are being implemented, that it's not being implemented because someone belongs in a protected category. So when we talk about vouchers and when we talk about credit checks, if the voucher itself covers the entire entire rent, then the question that I would have would be, what would be the purpose of that credit check? So that's one question. And then the other question is, if the credit checks, by having the credit checks, so sometimes a policy can appear neutral on its face, but if it has the impact, and we call it a disparate impact, if it has a disparate impact, a negative impact on a protected group, then that just raises a red flag, and that says we need to look more into this.
Mhm. Understood. I think that clarifies it a bit. We have a few questions coming in. Hind is saying, thank you so much for this necessary, valuable, and informative presentation. We know that there have been advocacy efforts to address fairness and transparency in co-op housing purchases when boards do not give reasons for denials. Can you speak a bit about this? Thank you.
So I'm not sure what.
I guess
Mhm.
the question is about co-op boards. They conduct the interview process, and then there are denials for no fair reason. It says advocacy efforts to address the fairness and transparency in co-op housing purchases when boards do not give reasons for denials. Can you speak on this issue?
Yeah, the only thing I can say is that, so I know in Suffolk County, there is a provision that if someone is denied, if they're denied if the application is denied, that there has to be notification provided. And so and that's an affirmative obligation. So if that's not being done, then what I would say, anyone who knows of that, then they should report that to us. But there is a section in our law that mandates that the notice be provided. And it's interesting because I believe Westchester was another county that had recently passed a similar law. But in terms of one of the challenges is the enforcement, as with anything when we're talking about housing. And that's why doing such things as testing in the Newsday undercover report is so very important. And also for people, if you hear, to report, because as we know, Suffolk County, 1.5 million individuals, is a huge county. And so what we like to say is that we have to partner with folks. So we partner with residents, we partner with those who understand what the law, who are becoming educated, and share that with us so that we can do the enforcement aspect of it.
I guess this is a question for either one of you. Can you please give us an example of implicit bias? Can you speak to that subject, maybe Lorena?
So like I said, implicit bias in and of itself, sometimes we're not aware of it. So I think one of the things is sometimes we may look at somebody, maybe somebody with a disability, and think that maybe they can't do certain things. And it's not something that we recognize right away. But I think that recognizing that that somehow we may have been biased against the person is important when it comes to, especially if we're making a decision based on that person's disability or that person's different ability. So it could be, maybe that they can't do the work because they're legally blind, or maybe they can't, maybe we don't want them in here because they're going to need an accommodation, or they're going to need to modify something. So again, just being made aware that we have these biases may help us in making better decisions. I don't know if I answered that.
Unmute. I think so. Let me turn my camera on. Okay. Implicit bias has become a required topic and a cultural competency. So part of the changes that have been made by the governor starting September 21st, anyone that renews their license, part of the required topics will be those two added topics, implicit bias and cultural competency. So we'll be hearing more and more of that. And we'll be doing some training on that for anyone listening in, just to watch for classes. I think that concludes the Q&A. A lot of thank yous. And I know your time is so valuable and precious, and you gave us time and always do. And we thank you for that. Okay. That seems to be it. Okay. So thank you so much for being with us, and I will be in touch, and for giving us the time and helping us to recognize April as Fair Housing Month and this topic so needed.
Thank you for having us, Marianne.
Thank
And
you.
as always, if you have any follow-up questions, just forward them to us and we'll answer as best we can, okay?
Will do. Will
Okay,
do.
thank you.
Elena.
All right, bye-bye.
Bye-bye.